This is NFA Talk, the show that talks about guns and gun rights, keeping you up to date with what's currently going on, from the newest guns, promotions, and events, plus how we're lobbying for your rights.
Hi, welcome to another episode of NFA Talk. Welcome to our viewers and listeners out there. I'm Sheldon Clare, president of the National Firearms Association. Tonight I'm joined with Ian Runkle, Runkle of the Bailey. I guess that leads me into my opening that you must be a John Mortimer fan, because there's no other way you would have chosen a name styled in that fashion.
I am, and there's also a fun moment where I was in court and a judge thought that my name was Rumpel and made a big production about it, but he was quite disappointed when I corrected him as to the actual name. But it made for a fun, it makes for a fun channel name. So, of course it does.
It seems appropriate. And you've been doing Runkle of the Bailey for some time now and getting a pretty good response, as I can see.
About 6 months, and I've been kind of blown away. I expected that at this stage in things, I'd probably have, maybe a few hundred people paying attention, but it's instead almost 24,000. So that's
and why do you think that is?
There's not a lot of Canadian legal commentary at all, but especially in the firearms sphere, things are so complicated and weird. Even lawyers have a lot of trouble figuring out firearm law a lot of the time. It's so there's so many complex twists and turns and so many ways that things can go wrong that I mean, this is why I really love firearm laws, that it's fascinating, but it's a terribly broken area of law. So there's always sort of something unusual going on in that sphere.
Well, that's for sure. And I mean, you and I have both been at this a fair time. I mean, I've been advising lawyers on firearms law for decades now. I remember getting pulled over by or stopped at a road check, the RCMP, and the fellow came over and he noticed I had a rifle in the front of the truck because my partner and I were coming back from hunting, and he promptly reaches for his pistol at his side and he starts telling us all this stuff, and I looked at him and I said, "Calm down." And he said, "Huh?" And I said, "Calm down." I said, "There's nothing illegal going on here." And and he said, "Well, I think there is. You should be doing this and this and this." And I said, and I reached into the back of my truck. I said, "I'm just getting a book." And I pulled out a copy of the criminal code. And I said, "Here, open that up and you tell me where I am doing something wrong. Show me the exact section that I'm committing an offense, please." And he looked at me, "Are you a lawyer?" And I go, "Nope, I am not a lawyer. I'm just somebody who is well read on a particular area of law." So, there it is.
I've seen several people who have have ended up having their matters go further than that, where they're driving around, post hunting. They've got an unloaded rifle on the passenger seat, and they end up in custody before somebody bothers to read the actual regulations and go, that's not actually against the regulations.
No, and it was a close run thing, but I mean, I had a fairly good relationship with the police and with the legal community on these matters, and I often get called about, "Well, Sheldon, is there something we should know about this? Is there an approach? Do you have some case law that's not published?" And often we do. Of course, that's become less and less relevant as more and more cases have gone through the mix and water's under the bridge, but there we are. Anyway, one of the things I wanted to ask you about tonight was mandatory minimum sentencing in Bill 238, the defeated bill, and why that bill was such a terrible thing. You did an episode on Runkle of the Bailey about it, but I think I wanted to delve more into the why mandatory minimum sentencing is so bad.
Well, the problem that usually comes up with mandatory minimum sentencing is that it really goes after the people you don't want to go after. Because if you think about the really bad guys, they're not looking at a minimum. They're looking at something that is well above the minimum. Even if there's no minimum, they're looking at something well above whatever you'd set that minimum as. Where that really ends up biting people is when you start talking about people who don't deserve it. People who deserve some penalty that's less than that. Because then you end up with the court saying, well, I'd love to give you a lesser penalty, but it's just not available here. And so, and it sometimes it can be hard to think of that scenario when you're looking at the law, but then eventually it sort of comes up. And there's various ways that ends up getting dealt with, but it was one of the things the court looked at with the case of the Queen and Nur, because there was a lot of people in the firearm community. I saw people who were quite upset saying, look at the courts. They've overturned this mandatory minimum, and these bad guys, because the people in that case were not necessarily sympathetic individuals, these bad guys are getting away with it. But the court actually said, listen, we're not necessarily worried about these guys here in court. They actually said, for these guys, the minimum is reasonable. They said, let's look at the reasonable hypothetical, so the other possibility. And the reasonable hypothetical they looked at was somebody who forgets to renew their license and thereby ends up holding a restricted firearm and ammunition. You might have a restricted firearm and ammunition in the same safe, which, if your license expires, is a criminal offense. So the Supreme Court said, listen, those people shouldn't be subject to a 3-year mandatory minimum. And, I agree. If you've got somebody who just forgets to renew their license, why should they be looking at a 3-year mandatory? And it's always that kind of situation that comes up.
Exactly. And that's one of the reasons NFA intervened in Regina versus Nur. And we provided several of the arguments which were cited in the decision when we did that. It was Solomon Friedman was representing us then. And it was a pretty important case. And it shook a lot of people because we were going after the mandatory minimums. And I know people who did not deserve to go to jail for what the mandatory minimums would have been for some offenses they had been involved with, who ended up with considerably lighter sentences because of that. And I was very pleased that NFA had played a small role in making that happen.
Well, and it wasn't long after Nur that I had somebody where the Crown hadn't really followed up on the changes in the legislation, and had said, hey, listen, your guy's looking at a 3-year mandatory minimum. Maybe we should talk a deal. And I said, he's not looking at any mandatory minimum. That was struck down. So he's not going to get bullied into anything. And, it was a much happier outcome for somebody who is a lot more sympathetic, somebody who had been, a licensed firearm owner and, wasn't at the time, but it's all of these laws get complicated. And once you start saying, hey, listen, let's tie a judge's hands, often that doesn't work out very well, especially because people get this urge based on what they see sort of in the media. They see some shocking story. And typically when you actually dig into these stories, a lot of the times they're less shocking than they sound. If you look at some of the coverage that came out around Ian Thompson, for instance. Some of it was very favorable to Mr. Thompson, but some of it was very unfavorable to Mr. Thompson. And so if all you were getting was that, latter area of coverage, you might think he was some sort of bad guy, but really he was just, somebody trying to, not get killed. And so it's very easy to get this distorted view of these cases and to get very upset by them because you're being fed something that's not accurate.
And the problem that I see it is mandatory minimum sentencing has kind of become a political issue, because you often see the conservatives, for example, arguing for mandatory minimum sentencing because they want to be seen to being tough on crime. But I've had discussions with some of my good friends who are of that sentiment. But one of the examples I used as a historical example was the execution of Admiral Byng on the deck of his flagship, the Monarch, in 1757, after he was charged with failing to do his utmost. Sounds like an innocent enough charge, right? And the problem with the charge was that it carried a mandatory sentence of execution. The sentence was execution. That's it. There was no, life in prison or get cashiered or go on half pay or anything like that. And no one on his court-martial board wanted him to be executed. They all thought, well, you left in the face of the enemy. You could have done more to stop the French, but instead you saved your ships and you went away. And so they found him guilty of failing to do his utmost. Then the president of the court-martial said, well, you are to be taken from this place to the deck of your flagship and executed by firing squad. And everyone went, what? So mandatory minimum sentences don't often have the desired outcome. People look at them and go, wow, this is not what we wanted. This wasn't justice.
And if you look at historically, one of the interesting consequences, if you go back, is they used to have the death penalty for all sorts of crimes, this huge range of crimes. And one of them was poaching. So, if you took the king's deer, that was a sentence of death. And what they found is that it was very difficult to get people to convict on poaching, even where you had somebody, where it's like, well, we caught him in the king's forest with a bow, carrying a deer that had an arrow stuck in it that matched the arrows on his back, and when we asked him what he was doing, he said, I poached me a deer and I'm going to eat it. And they'd take that in front of, a court, and the court would say, nah, we don't think he did it. And the reason why...
mandatory sentence.
It's because of the mandatory minimum. They thought, he did it, and if the penalty had been like a fine, they would have said, okay, you did it, you got to pay the fine. But when the penalty was death, they were unwilling to convict because they felt that the penalty was too high. And you see that with juries, in all sorts of scenarios where they say, and juries in Canada are not permitted to do this, but we don't really have a way to detect it. But you get this problem where if the juries don't think that the result is necessarily going to be fair, they may not go along with, what they're supposed to do.
Is that not allowed in Canada? I thought it still was. A jury could say that the law was flawed.
Juries are not supposed to engage in nullification. It's the judge's job to decide the law and whether the law is proper. However, one of the most famous, Canadian court cases, that being Morgentaler, is a jury nullification case. And that one got sort of batted back and forth with juries saying we refuse to convict and courts saying, no, that jury was wrong, send it back. Until finally the Supreme Court said, hey, we're putting an end to this by adopting a different interpretation of the law. But, in practice, how do you prevent it? Because you can't interview jurors after the fact. So what happens in the jury room is a bit of a black box. So it could be that juries, are still doing that even though they're not supposed to, or it could be that they're, not. But regardless, juries aren't supposed to do that. They're supposed to leave the actual decision on the law to the judge. And so, but historically, we've seen that this is something that, juries and even judges will do, is they'll say, listen, I'm not going to convict here because I don't want, I don't think the outcome is fair. So
exactly. The last time we met, Ian, we went out for lunch when I was in Edmonton, and we had a very, very pleasant chat for a few hours, as I recall. And one of the things that you pointed out to me that I was really quite distressed about was the fact that the judicial activism that had been swept through our legal system by the previous Attorney General had actually removed some pretty important stuff, one of them being Section 337. But there were other things as well that were swept away in that broad judicial activism. Do you want to talk a little bit about that?
Well, some of the things are preliminary inquiries, and those have been really scaled back. And what a preliminary inquiry is it's sort of a miniature trial before the main trial. And the standard for whether an offense goes from the preliminary hearing on is a fairly low bar. It's just that there's some evidence on each of the elements of the offense. And so in theory, a jury could, potentially convict on something like that. You're not, if the evidence is contested, so, you've got a witness who is probably lying, at the prelim stage, it can still go on to a proper, a full trial, because At the prelim stage, you basically take the Crown's case at the best it is. But I've had, several cases where after the prelim, defense and Crown sort of come together and say, okay, now that we've sort of seen a little bit about what this looks like, a full trial is unnecessary. And that might be because defense has looked at it and said, you know what, we're done. We're not going to be able to defeat this. But sometimes it's the other way. The Crown looks at it and says, I don't really like this. I don't like how our witnesses are going. I had, one where it took the judge a very long time to decide on committal. And the Crown, as a result of that, said, well, I don't think I'm necessarily going to win at the trial because I thought this was going to be an easy answer on, the committal to stand trial. And if it took the judge this long to make that call, and so we were able to come to a resolution. So a lot of preliminary inquiries save time, but this was eliminated sort of as a time-saving measure to try to speed up the time from people being charged to their eventual trial.
And it took away rights that have been present for people for a very long time. Like this is something that people, we're going to examine the evidence and make sure there's something here, right? And all of a sudden it's being rushed through.
And, if you think about, how much to an accused, going through a full trial is very expensive. There's not a lot of times when a preliminary inquiry, knocks out charges. But when it does, it's a great benefit to the accused because then they don't have to run a full trial on those. And a preliminary inquiry is typically very much shorter than the larger trial that it sort of precedes, because the Crown doesn't need to go into its full evidence. They don't need to prove everything beyond a reasonable doubt. And the defense and the Crown may have agreed that they only want to explore certain issues at the prelim. We only really want to look at, this search, or we only just really want to hear from this one witness. And so it can be a way to save a lot of time and effort, just because sometimes both sides see what a witness looks like and that can decide it. That can really settle how the case is likely to go and come to a resolution.
Of course. Were there other aspects of that swath cut through the criminal code that we didn't like? I mean, I didn't like the 337, which was the offenses resembling theft part, in which you could, and we've used this many times to stop anything from going to court. It's been one of my favorite sections in the entire criminal code, because I would call up an officer and I'd say, hi, I've been given this file. That was a great way to start. And I'm looking at it, and I'm just not seeing why this person hasn't had their firearms returned to them. And I'm wondering if it's a Section 337 issue. And they go, well, what's Section 337? And I said, have you got your Martins or your Greenspan handy? And they pull out their criminal code and they're flipping to it. And then there's this long pause while they read 14 years. Indictable offense for not giving back somebody's stuff. And
yeah, as written, that's one of the very few sections that actually sort of provided power to the ordinary person, that said, listen, and for people who are unfamiliar, what this section said is basically, if a government official has been entrusted with something and a person has a right to demand it, and they do demand it, and it's not handed over, then that's an offense. And it's, was a very serious offense. Unfortunately,
14 years.
Yep. But it wasn't being used properly. It never seemed to make it in front of the courts. And the big problem with why it wasn't making it in front of the courts is that how do you get the police to lay the charges against the police?
Oh, no, Ian, that's not why it didn't get to the court. It got to the court because people like me would say, is this a Section 14 or a Section 337 issue? Do you want to bring your supervisor out here and have a look at it? And I talked to a lot of watch commanders about some overzealous constable or property manager who would not surrender somebody's firearms back to them. And I remember one old staff sergeant, the old grizzled down at the RCMP office, and he flipped the pages and he looked at it. And he looked at me, and I had this little smile on my face. And he looked at that and he said, can you leave this with me? I'll get back to you tomorrow. Is that all right? If we do that, would that be okay? And I looked at him and I said, certainly, staff. I think that would be really, really quite good. And the next day, what would happen is he'd call the person up and they'd be directed to come down and pick up their stuff. And there's no charges. It doesn't get to court because it exists. It's exactly the purpose of law. It prevents bad behavior.
The thing is, as a sort of negotiating tool, it was fantastic. But I think that there were situations where they should have laid charges, because there are situations where people have had to fight in court, having already gotten a court order that says give the guns back. They have to go and get a second court order that says really give the guns back. And to my mind, at that point, it should just be like, no, if you don't give the guns back, trouble is going to happen. That's what a court order should really mean. But the main problem with why charges aren't laid is, who do you get to lay the charges on that one? The police are not inclined. The Crown is not inclined. So
I remember going into a police station one time with a fellow, and I went in there and I said, I'd like to report an offense. And the person at the desk, the officer at the desk, said, okay, and where did this take place? And I said, right here.
I can imagine that went over well.
It was a 337 thing, and we'd been going through the ringer with this. This guy had been trying and trying. He'd gotten a lawyer. The lawyer told him that there's nothing he could do. And I said, well, that's not okay. And he called me and I said, this is what we're going to do. I'm going to be your witness, and I'll go down there and I'll talk, and then you just look very stern and sad at the same time. And we went in there, and I said, it happened right here, and we'd like to lay a charge. And the guy said, well, what's the offense? And I told him, section 337, there's your green span right there. And flip, flip, flip. And he read it, and it was like, oh. And so what happened? And he had questions. Well, was this constable so-and-so? Here's his number. Here's his name. Here's the information. And he has this stuff, and he was told to give it back by the judge, and he did not do that. And he's been stalling for months. When we want this resolved, or we want this constable charged. and this was a game. Let me see if he's available. I'll get him. And sure enough, solved, just like that.
Yeah, well, some other changes. They eliminated peremptory challenges for jurors, which basically means that in most cases, your jury is sort of the first people who show up and aren't immediately disqualified. It really removes the ability to do anything about your jury. And, there's some provisions for challenging jurors, but in Canada, they're quite limited. And so this was done as a result of the verdict in the Stanley trial. And the Liberal Party has had several of these things where they see a result on a trial that they didn't like, and so they try to change the law to make sure that could never happen again. But ultimately, in my view, it's going to hurt a lot of Indigenous accused, because you can come in and, somebody walks in and gives your client, real stink eye, and you just know that person hates your client just from seeing him. And, previously you'd have that peremptory challenge to say, no, thank you. I don't want you, I can see you're shooting daggers at my client, no. But now, no, you got to let that person on.
Yeah. And it's the word prejudice, right? Prejudge.
Yep.
If you see that someone is prejudging your client, you want to be able to shut that down. And now you cannot. Thank you, Jody Wilson-Raybould.
And another one that I think people will be quite surprised at is the law has now been changed to make it so that it is an offense to drive home sober and then get drunk, because prima facie, it's an offense to be drunk within 2 hours after driving. So they changed it from it's an offense to be driving impaired to it's an offense to be impaired after you've driven home. Now there's a defense where you can go through and try to establish that you were sober at the time and that you had no reason to believe that they would ask for a sample, and that you have your numbers sort of read back by an expert. But that's going to be very expensive. So it's, in theory, the police aren't doing anything wrong if they see you driving sober and they know you're sober, and, you get home and you get drunk and then they charge you.
So you drive to the liquor store, you pick up a nice big fifth of bourbon or a bottle of good whiskey, and you drive home. The police officer waits outside the liquor store, watches you drive home, gives you an hour, and then knocks on your door.
Yep.
And you're
And
done.
if you open the door and, you could end up getting charged for, hey, you have been drunk after you were driving.
Wow.
You drive to the bar after work, you sit down with your friends, you have a bunch of drinks, and you get out and you look at your car and say, nah, I've had too many. I'm going to call a taxi. I'll let the bar know, hey, listen, here's my car. It's parked in your lot. Please don't tow it. I'm too sauced to drive. I'm going to take a cab. And you can still end up getting charged and having this massive, you have to essentially go at that point and prove that you fall within this exception in
Wow.
order to avoid a conviction.
And
So
this was done probably to stop the person who gets into an accident and maybe has been drinking, and then sits at the side of the road, pulls out a Mickey and downs it right there in front of witnesses and said, oh, I got drunk after as I was so stressed. Is that what this was about, probably?
that's what they're trying to prevent. But I mean, it seems to me that the better way to do it is either to go with obstruction of justice charges, which have been used for this in the past,
Yep.
or perhaps to make it an offense to consume alcohol after a accident. Something along those lines, to say, if you've been in an accident, then it is an offense to consume alcohol within, 2 hours. That way you can say, hey, listen, you've been in an accident. You've got to give the police an opportunity to go and, breath test you. But
Yes.
it's funny, the cases that I'm sort of familiar with where I've seen people actually do that, it's been police officers. So,
Oh, no.
well,
That's
I mean,
unfortunate.
they're, sort of more savvy individuals. And so that's sort of where that has tended to come up, as opposed to, the average member of the public doesn't think that way. They, if they get into an accident, even if they're impaired, they don't typically think, now it's time for me to start getting drunk.
No.
But I have seen people who, got into an accident and then thought the accident was settled. They thought they'd worked things out between them and the other person, and then go into a bar to wait for the tow truck. And then after that, the other side says, I'm pretty sure he was drunk, because they saw him go into a bar. And now, but typically that was able to be resolved with, like, the bartender says, no, the guy was sober when he came in. He's not sober now, but
Yeah.
he was sober when he walked in. And they say, okay, fine.
Reasonable doubt.
Yeah, but I mean, an offense to say, you can't consume alcohol, afterwards, unless you've been either cleared by the police or, 2 hours have passed. That would have been a much better way to do this, in my view, because that way it established, the burden is on the police. It's not a situation where it's that where the sober, innocent driver is going to be facing charges.
Sure. What about the reverse onus stuff that's in the criminal code all over the place, especially with regards to the Firearms Act? I mean, that's something we run into occasionally, where you have to prove you're innocent rather than they prove you're guilty.
Now, me and the Supreme Court have a disagreement on this one, because the Supreme Court has upheld reverse onus on bail. And I think that makes very little sense to me, because you have a right, it's a charter right to reasonable bail.
Mhm.
And so normally, for most offenses, the Crown has to prove that you should be detained. However, now they've put in all of these reverse onus things. And in fairness, that started, I believe, under Harper, but it's been, every government, sort of seems to think of a new offense they want to add in there. And, the Liberals have done it. The Conservatives have proposed doing it. I'm sure we'll see more sort of getting wedged in there. And eventually it stops being that you feel like you have a right to reasonable bail, and starts feeling like, you have no right because you have to prove it. And typically where that weighs most heavily is on people who don't have some sort of assistance of counsel, because if you're not able to make those arguments, one thing you'll see is that people who are not sort of familiar with the system tend to make the wrong arguments, because the grounds for denial of release tend to be things along the lines of, or, one, you're not going to show up for court. Two, you're going to commit further offenses and pose a danger to the public. And three is sort of this catch-all that it would bring the administration of justice into disrepute if you were granted release.
Of course.
But what people tend to argue when they're, if you just pick somebody off the street and say, now you've got to argue for why you should be released, they say, well, I'm going to lose my job, and, I've got kids, and I've, so they tend to focus on the consequences to them.
And the sympathy play doesn't work.
I mean, the court will say, these things, they matter, but you got to hit I'm going to show up for court, and I'm not going to commit further offenses. And there's ways you can use those things to establish those issues. This individual's got a job, so he's, unlikely
he's not a flight risk.
Cars, and he's not going to be fleeing the province because he's got a job right here, that he's got ties to this community, that kind of thing. But people don't really necessarily understand that. And so it can be a very difficult thing, because now they have to show that they should be released. And a lot of these are sort of aimed at, firearm offenses, because a lot of politicians sort of don't like firearms. Even the sort of conservative politicians, when they think of where they can score sort of easy wins, it tends to be on firearm issues, because they say, oh, there's these bad people running around. But it's really difficult to frame a firearm offense in a way that doesn't potentially also capture people who aren't bad people, who have somehow screwed up and, are very much, not who we're thinking of.
Right. And I mean, the political agenda in the next federal election is very likely going to be something that is affected by a firearms issue. So what do we see there? Is it going to be something where people are going to have to make a decision on their political party based on a fantasy? Like, are they going to try to go after us and say, well, firearms is an issue. You either win big or lose big, and we're thinking if we go with firearms, we're going to lose. So we're not going to assist on firearms issues.
Well, firearms is an area that politicians love to use to sort of score cheap points. If we remember when Trudeau was running, they were running these ads that said, the Liberal or the Conservatives, want to make it so that you can, take your guns to the shopping mall, your handguns to the shopping mall. And, it's like, no, that's not what that law said. Not even a little bit. It's a lie. I mean, there's no other way to put it. It was just because either it was so lie. Well, I mean, either they were so clueless that that it's unjustifiable, or they were trying to mislead people. There's not really any way around it. It was that law did not do what they said. And so but now what I suspect we'll be seeing is probably the rhetoric around, assault rifles and so forth, which again is dumb, because the AR-15, as far as I'm aware, has been used in a homicide once in Canada. And from my understanding, that wasn't a lawfully owned AR-15. That was one that was smuggled in from the United States. So it wouldn't have mattered either way. But they are used quite a lot by sports shooters. They're used by people who are participating in 3-gun, and they're used by people who are participating in service rifle. And if you're out at a service rifle match, what you'll see is a lot of people who are veterans. A lot of people who on November 11th will be at the Legion wearing their medals. And, so when you think of who that law ended up actually targeting, it's not targeting criminals. It's targeting people who are just, wanting to keep their head down and be decent members of society.
And who are the best possible citizens in the country. And
yeah, it's, you know,
these are rifles that are called the modern sporting rifle. They were used for hunting until C-51. They were used for hunting again through most of the 80s until Tim Campbell restricted them again.
Yeah.
And then they've been very, very popular for sports shooters, and many people would like to see them return as hunting rifles.
I mean, honestly, if they were moved to non-restricted, which by their features, like, if it wasn't for the ban by name, by their features, they'd be non-restricted rifles because they're very similar to many other non-restricted firearms on the market. So, but if they return those to being non-restricted, you'd see people hunting coyotes with them. You'd see people, all sorts of things. In the States, they come in all sorts of calibers. 223 here is, it's not legal to hunt deer in Alberta with 223.
It is in BC.
Fair enough. They do make them in larger, chamberings. So there's people in the States who, their AR-15 is their primary deer rifle. It's just they've got one that's chambered in a slightly larger caliber.
Well, they make them in 300 blackout or 7.62 by 39, and there's all a range of calibers now.
Yeah, and the Mini 30 is a very common hunting rifle. Mini 14, lots of farmers have them because again, if you've got coyotes, you don't want something where it's like, hey, get out the muzzle loader. This is a situation where you want something where you can, maybe take out 2 or 3 instead of just one and then the rest flee. So,
or a pack of wolves is the classic thing. I mean, coyotes tend to be more solitary than wolves, but wolves are a real threat, and predator control with these is a big deal. And feral pigs are a problem too.
Yeah, no, and there was sort of the meme laughing about this, but feral pigs are nasty. People underestimate it. Pigs are actually very, very dangerous as livestock, but once they go feral, they're even more so. I'm not sure that I'd want to go out and run into a number of pigs with a bolt action rifle. That's something for a semi-automatic rifle, and ideally one, where you can change magazines in a hurry. But they've sort of identified these firearms that they don't like. And of course, they're now using the variant term to apply this to, a series of firearms that is way beyond what's actually named. So you've got, the modern sporter and various other things where they previously said, oh, right, this is not a variant. And now they're saying, well, actually, we've changed our mind. It is a variant. We'd like to see it covered under the ban.
Well, they're not. It's not about stopping crime. This is entirely a civil disarmament agenda.
It's just, I'm not even sure that they're even thinking about civil disarmament. I think they're just thinking about political posturing. It's just they want to, gun owners and especially owners of sort of scary guns are an easy target. And, it's easy for them to go after this group and, score some points on it from people who are not terribly familiar. And I've had people, tell me that they had, they're telling me how an AR-15 works when they're not sort of gun owners. And often they're wildly wrong. They'll say, oh, what do you need a fully automatic rifle for? And I go, what are you talking about? Like, that's not on the table here. The AR-15 is not. And they're like, what?
I know. It's incredibly stupid.
Yeah, well, and the RCMP didn't get their wish list item on this one because I know that the RCMP have requested repeatedly that they want the SKS added to some sort of ban. But, the reason why I think it was left out and is partially the reason why the RCMP want it on, which is that it's incredibly popular as a rifle on reserves because you've got people who may not have a huge amount of money but need a reliable, dependable hunting rifle. and 7.62 by 39 will get the job done on, all sorts of game. And so it's a $300 rifle that, or was, prices have gone up.
That's true.
But, it'll get the job done. And so, but because they're everywhere, they end up being used in crime. And it's not because the SKS is a particularly criminal weapon. It's just because there's lots of them.
That's very common.
It's like saying, why are there more homicides with hammers than there are with, some specialty mechanics tool?
Yeah.
Yeah. And it's like, well, because there's more hammers. Most people have a hammer. They may not have, some other instrument.
And I think it goes back to the essence of the whole problem, that it isn't about the firearm. It's not about the weapon used to commit an offense. It's about the human behavior that's involved. It's the person.
Yeah.
And so you deal with the person. You don't deal with the thing. And the thing doesn't make it any more or less dangerous.
Especially they're really trying to target behavior. Like a lot of this violence and a lot of this crime is committed by people whose occupation, is some form of criminal activity.
Exactly.
So, if you ask me, what do you do for a living? I say, hey, I'm a lawyer. If you ask somebody else, they might say I'm a mechanic but these are people who might answer something like I'm a drug dealer. And, when you start thinking about it, the reason why drug dealers carry firearms is that they view it as an essential tool and often as a means to preserve their own life against dangers inherent in that occupation. But saying like
cases on that.
Well, and there have been self-defense cases where it's, somebody has used a firearm in the course of, a shooting and killing somebody. And notwithstanding the fact that they are involved in criminal activity, they get acquitted on the actual violence because they were facing a serious threat. And even bad people are entitled to self-defense. So, even people who are involved in criminal activity at that time. But, we're not going to be able to successfully tell them, hey, listen, this is banned, stop doing it, because it's already banned for them. And we're not going to be all that successful in telling them, listen, you can't get guns because even if we had a magic wand to eliminate every single gun in Canada, just wave it and they all vanished right now, there'd be new guns coming in, because we're talking about people whose occupation is moving contraband into Canada. So,
or there would be substitution.
Yeah.
Right? That's the common thing is you see one resource is moved away, another resource comes to fill that void.
People start using knives. People start using the one that they've seen in the UK, which is acid. And if I'm thinking of what do I want people, running around with, acid is real low on the list. But there's, only so much you can do. You run into problems like eventually people will manufacture firearms. You see this in the UK, you see this in Australia, where they've got, these home firearm manufacturing businesses that have sort of cropped up. And the danger with that is that when you've got that form of substitution, people don't make a 1911. A 1911 is, it's complicated, it's precise. They make something like a Sten gun because a Sten gun is designed to be sort of easily stamped out. And, if you're making an illegal firearm, why not make an illegal fully automatic firearm?
Well, that's it exactly. And I think what people don't understand when they're trying to regulate firearms is that they are actually very low-level technology.
Yeah,
you need a tube, you need a propellant, a projectile, and something to force the energy out that way. That's it.
Well, and I've told people I could make a fully functional firearm out of stuff sold at Home Depot, like everything that is just sold out of stuff at Home Depot, and it wouldn't be that hard or take that long. And people go, what? And it's like, no, it's actually not that hard. They're very simple technology. It's basically a tube with one end blocked and some sort of way to, set off the powder.
Yep.
That's it.
Yeah, or any kind of rapidly expanding material that'll force a projectile down the tube. I think I learned a lot about that when I saw a museum at a prison, and they showed various weapons that had been made by inmates in prison,
Yep.
including various forms of zip guns.
Oh yeah, I mean it happens all the time. There was one where in a U.S. prison, somebody lost a magazine. You know, one of the guards was not supposed to have the magazine, but he had it in his pocket and he lost it. And in the course of this, because this magazine and with the cartridges, somebody went, well, now that I've found these cartridges, I might as well make a gun to go with them. And so it actually sort of went the opposite way. But people, there was a famous case of a guy who built a firearm to kill himself in a U.S. prison, and did so using playing cards as the propellant. So it's really difficult to prevent this. We can't prevent drugs from getting into prisons. We can't prevent weapons in prisons. And prisons are really the most regulated environment. It's an area where, you know, you can be subject to search at any time at a whim, which doesn't apply, you know, here in sort of open society. This notion that you're going to be able to stop criminals from, you know, having firearms by banning law-abiding, you know, people from them, it just doesn't hold up.
No,
It's
no, it certainly does not. And I think when we are looking at what we're doing now to challenge the order in council with our case that we built around Cassie Parker and KKS Tactical, which we're intervening in as well, we figured that the compelling client is the way to go rather than the evil gun lobby, you know, NFA versus anything. That wasn't the path we decided to go with this because we didn't think we were the compelling client.
and you know, I'm glad to see there's a number of sort of angles on the challenge, because I think that that's always a good thing. But I often with a test case, you want a compelling client because you want somebody who's going to be sympathetic, who's going to be, because as much as, you know, going into law school, and for a lot of law school, you sort of think, hey, you know, these are judges, they make decisions solely based on the application of law and so forth. But everyone involved in the system is a human being. And
Exactly.
My torts professor at the time liked to use the Western analogy, which is that, you know, people walk into court and the judge is going to spend a lot of time deciding who's wearing the white hat and who's wearing the black hat. And that almost invariably the person who the judge thinks is wearing the white hat is going to win. Now, that torts prof was Russ Brown, who is now sitting on the Supreme Court of Canada. So,
yes.
You know, I like to think that he knew his stuff when he was, you know, telling me these kinds of things. But that's often how the court views it is, you know, if the court doesn't like the person, they'll find a way to, you know, convict them. And I think we can see that in some past court decisions. If you look at the case of the Queen in Falauca, people like to point to that case and say, well, I'm not anything like the guy who was charged in that one because that guy was behaving real badly. But in order to convict that guy who was behaving real badly, they put the law into a state where it's going to affect all sorts of other people. So sometimes it can be really important to have somebody in front of the court who is sympathetic and who the court can, you know, can relate to in some fashion, or at least can say, even if we don't relate to you, you know, we don't think you're a bad person. We don't, you know, we don't actively dislike you, kind of thing.
And exactly. And that was really, as part of our strategy, was to find somebody that is a compelling client that the court will listen to and not prejudge based on a handle, like, you know, well, this is just the gun lobby taking a case for it. No, they're not sympathetic at all, right? We didn't want to be tied to that in our situation. That's for sure.
Yeah, I mean, it's not clear how how they'll react to sort of, you know, firearm lobby or whatever. But the last thing you want, you know, would be to run this, for instance, you know, with a here's a guy who is, illegally selling AR-15s that he smuggles in from the States and is now worried he's going to get a stiffer sentence. Like that would be sort of your worst case scenario client.
That's right.
So, and you can see some of this has happened in, the Crown has a tremendous power to pick who gets to run a test case. So when you look at things like the issues with, 1022 magazines.
I was just going to bring that up. Exactly.
I'm aware of a number of cases where they've found somebody with 1022 magazines, with a capacity of 50 rounds, 100 rounds, whatever, and said, we're just going to drop this one, including in some cases, and give you back the magazines. But in a lot of cases, just how about we'll just settle this for we keep the magazines. But of course, they're waiting for a situation where the guy charged is somebody who's also found with a kilo of heroin and, a lengthy violent record. They're wanting somebody who, they're like, can we find somebody with a facial tattoo? Can we find somebody, who's just as unsympathetic as possible? And then we'll run this.
And we've been looking for that client to challenge that particular provision because we think it's a winner.
Yeah,
the law is clear. I
mean, in private practice, I had several files with 1022 magazines. And in each case, when I said, hey, I want to run this and I want to challenge your interpretation of this law, they said, we're going to back away from that one.
Yeah, they all caved, which is good for your client, but not good for fixing the problem.
Yeah, I mean, it illustrates one of the problems when you're a sort of a lawyer with an interest in a particular area of law, because, of course, I have to act on the client's interests, not on mine. And so, if they're offering something that's good for the client, it's like, well, you should take this, because, hey, they just want to keep the magazine. The magazine's, a $50 value. And, at the end of the day, it'll cost you way more than $50 to take this to trial. And all you'll get if you win, it'll be beneficial for the law and for everyone else. But you're not going to be that much ahead. You're going to be $50 ahead. And, very few people are going to say, you know what? That sounds like a great plan. I totally want to sign on that.
Yeah, my principles are worth more than the magazine, is what we're looking for, is somebody who's willing to take that on.
And I mean, it's not something where I could even recommend that. It's just like, listen, this is an option and it's crazy, and I recommend you not do it because, it's but really want to just settle this.
But if you want to, good for you, and we'll.
Yeah, if you want to, good for you. But again,
it's not the best option.
A bad idea. Yeah. So great. Yeah, I mean, but you're going to end up with somebody who's sort of an unsympathetic accused, eventually getting, facing the trial on this, where they don't say, "Oh, we'll give you that option," because it's you we want to run this on.
Yeah, exactly.
You will get the precedent on, and so the Crown is able to shape that sort of who gets to appear on something. Why not do it on our end too, where it's beneficial? So
here. Well, Ian, we've covered an awful lot of topics tonight, a good wide range of swath through Canadian firearms law and everything else. I think that's probably good for our listeners and viewers for this show.
Fair enough.
You'll have to talk again, and I want to encourage everyone to take some time and visit Runkle of the Bailey on his YouTube channel. It's out there with really good, punchy interpretation and analysis of Canadian law for those, especially firearms law, when we run into those little problems that maybe need a little bit of analysis. And Ian's very good at it, and I encourage you to listen to his show, his program. And we're very proud to be one of your sponsors, Ian.
Well, thank you, and I'm glad to have you there. And it's, I mean, I'm privileged to be able to, to explain some of this stuff to people, because a lot of the time I see online people, not trying to be jerks. They're just having disputes because nobody knows what the law is. And the law is so badly worded and so badly that they just, people trying their best to explain to other people, and somebody's got to be wrong in that one. So when I see those things, I've been trying to sort of do videos to cover the common disputes and say, let's try to settle this one out.
I'm trying to remember the name of I think it was a Queen's Bench judge in Alberta who said that the law was torturous. The Firearms Act, the writing of it was a torturous example of the worst way in which to write law.
The problem that we run into is that over and over and over again, it looks like the law was made without necessarily understanding firearms and without necessarily understanding the range of it. This especially comes up when we start looking at what I call 84.3 firearms, which are things like air guns and nail guns. And because when you start thinking about nail guns, you end up with all of these weird circumstances where, it's illegal to conceal a nail gun. Like, that's not what they were thinking when they said, we want to make it illegal to conceal a firearm. They weren't thinking nail guns. They were thinking, shotguns. So, or pistols or whatever else. So, yeah, it's complicated. There's some sections that they're just, I could go on and on. Maybe I'll just leave it there because, it's badly written in a lot of places. And I just did a recent video covering a proposed bill in the States that would have been, that if it goes through would be incredibly badly written and would have all sorts of negative consequences. So it's not limited to here in Canada. It's an overall thing.
No, that's for sure. Okay, well, that's probably a good place for us to end our NFA talk this evening. I want to thank everyone out there for tuning in, and especially thank Ian Runkle, Runkle of the Bailey, for joining us this evening on NFA Talk.
Thanks for listening to this episode of NFA Talk. Like and follow the NFA on social media and sign up to become a member.